Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be talking about the WARN Act, or the Worker Adjustment and Retraining Notification Act, which was enacted in 1988 and became effective in 89. And what this act does is it provides protection to workers in their community by requiring employers to provide notice 60 days in advance of covered closings and covered mass layoffs. And this notice is supposed to help sort of guide resources towards the area in order to help transition those workers into other roles or elsewhere. So, in an era of mass layoffs and sort of escalating tensions here, I decided we ought to dig into the WARN Act and see what we can expect in the future.
And the employers that the WARN Act covers are pretty important. So in general, they have to have more than 100 employees, and that can't include employees that have worked less than 6 months in the last 12, and not including employees who work an average of less than 12 hours a week. It can include it does include government employees, public and private, profit and nonprofit, etc. And all employees who are considered hourly or salaried workers are covered under the act. I think that's really important. Obviously, for example, a small restaurant that closes down won't be covered under the act unless there's a specific state act that overrides it, like in New Jersey, and I believe there's a few other states. So, what starts the process? Well, one of the things is a plant closing. If a covered employee closes down a site that results in 50 or more employees lost, there this will initiate a WARN Act notice. So, in this scenario, if I gave a quite a little bit larger of a restaurant, that could be covered under the WARN Act, and that's important to know. So, what triggers the WARN Act? Well, it's a little varied. So, they must give notice if there is an employment loss for more than 500 employees at a site at any given point, or if there's a site of 50 to 499 employees, if the laid off employees make up at least 33% of the workforce. And there is some exceptions, and obviously that doesn't include resignations, and it also doesn't include terminations for cause, which means there's a lot of leeway there, especially when there's rumors of plants closing and layoffs. Many people may just decide to move on their own way and go elsewhere. And so a lot of times employers are able to lay off or terminate a significant amount of employees without triggering the WARN Act. So there's a couple exceptions to the WARN Act, and that's really important to talk about. Um, you know, the exceptions are to the 60-day notice is a faltering company that just, absolutely just is basically teetering on the edge, as well as unforeseeable business circumstances. I would say that, for example, the COVID Act or COVID would be a sort of a dereliction of the WARN Act, as well as natural disasters where an earthquake hits. But all it requires is a 60-day notice to specific parties, which include government organizations, local, city, and state, and potentially and federal. Um, and they're supposed to sort of bring resources in order to manage the WARN Act appropriately. So that's all the WARN Act is. Now, companies can get in trouble for not following the WARN Act, but it's really such a toothless act in terms of its application that it's really not worth talking about too specifically, other than you'll be hearing it a lot more in the coming months. Well, on that dour note, that's it for me here at Human Resources for the People. It's a human capital revolution. Leave a like and a comment. Please subscribe, and we'll see you on the next one. Bye, guys.